plenty of news from the US over the last few months to say about former President Donald Trump and his running for office again. And of course, I believe he's leading the primary for the Republicans right now, and Biden's leading the primaries for the Democrats. So we could be back to doing that again at the US election later this year. But that's all I'm going to say on the subject, because there were some other interesting developments in the ongoing case about Trump's alleged electoral interference in Georgia from the last election that's still going on. To that end, joining us today is Andrew Fleischman, a criminal defense attorney in Georgia. Thank you for joining us today.
Thanks for having me.
As was mentioned, there is among the many charges former President Donald Trump is facing are those he and 18 co-defendants are facing in Georgia under the Georgia RICO trial. And there have been a lot of developments. That's what we'll be talking about today. But I think if we can then start with the basics of this, the situation going on in Georgia centers around the prosecuting attorney who is brought those charges to a grand jury and is bringing them forward, District Attorney Fani Willis, and some of the developments that have happened lately with the special prosecutor in the case. But let's start with something very basic, especially for our Australian viewers. Andrew, what exactly does a district attorney do, and how is that line between someone who she is both a politician, an elected member of the Democratic Party, but also an officer of the court and someone in justice? How does that balance work? Does that balance work?
Well, I guess there's pros and cons to it, but in Georgia and the United States generally, we elect district attorneys who have the sole responsibility to bring indictments and decide which cases get brought, how laws get enforced. It's a very powerful position, arguably more powerful than most judges. And there are upsides and downsides to elections, of course. I mean, the alternative would be an appointment system. Not everybody appointed is good. Sometimes they're just somebody who knows the governor. Elections means that people, say in Florida, could pick a reform candidate if they want, or a tough on crime candidate. And those choices are just part of how the American system works.
And then now in this case, or I should say cases, these sprawling cases dealing with a term that we're going to be saying, I think, a lot in this interview with RICO. What is RICO, and how is, say, the Georgia RICO statute issued here different from, even if our viewers have heard of maybe other kind of RICO in the United States? What is it, and why is it so darn complicated?
So RICO was initially a federal law meant to target criminal organizations like the mob or the KKK. It dealt with the fact that people at the heads of these organizations are often not directly connected to crimes. And so it allows you to target those organizations and claim that there's an overall agreement to an unlawful aim, and then turn lawful actions into criminal actions as part of that overall aim. That's the goal of the RICO statute. It also has powerful forfeiture provisions that have been used, for instance, to take money from the KKK. That's one purpose for it. Georgia's RICO statute has very similar language to the federal statute, but has been interpreted even more broadly. So, for instance, the Georgia statute does not require that the conspiracy exist for more than a year. It does not require any sort of explicit agreement. In other words, it's very broad and easy to abuse. And we see other cases in Georgia where people have protested about the way that it's been used.
And it is interesting you bring up like the mafia, which seems to be the classic use of it. But I was surprised in researching this to see that, for example, Georgia RICO has been used against teachers in a cheating scandal. So it does seem that almost anything can be caught by this. Is that correct?
The law seems to be abused more than it's used for its intended purpose. I've seen it used against court reporters whose font was too big. A court reporter is a person who writes down what happens in court, and they were using too large a font. RICO. I've seen it used recently against people who are protesting the construction of a training center for a police facility in Georgia. And this government's theory is that protesting, it makes you part of the RICO conspiracy. So I will say that no court has ever narrowed the interpretation of the Georgia RICO statute, but if they don't, it's really ripe for abuse.
And I think then that brings us to kind of the issue here. So we have these RICO charges against 18 co-defendants, and especially the charge of a co-defendant, Michael Roman, who's been accused allegedly of being involved in fake electors, and taking the lead in this is a special prosecutor by the name of Nathan Wade. is, given how unique and special this Georgia RICO statute, in your opinion, was Nathan Wade a good pick, a surprising pick? Is this, before even getting into the broader questions, what are your kind of thoughts on handling a case this complicated and his record?
Well, it is an especially complicated felony by Georgia standards, and so you'd want someone with a lot of prosecution experience. Nathan Wade notably worked for a year doing misdemeanor prosecutions 15 years ago. That's all of his prosecution experience. So you'd probably want someone with more experience than that. The Fulton County District Attorney's Office has something like 150 attorneys, lots with much more felony experience than that. So to that extent, given that you want someone with special skills and knowledge who's bringing something unusual your office can't provide to the job, he seems like an unusual choice.
Yeah, I think something important to clarify here is you've mentioned the Georgia RICO and the federal RICO acts. Now, why is this case being brought under Georgia law? Because it's about the federal election. So why is it brought under Georgia law instead of federal law in this case?
Well, it's being brought in addition to federal law. So there's currently a federal law that addresses the same conduct brought by Jack Smith in Washington, D.C. And that deals with an overall conspiracy, but it's brought much more simply in like 4 counts. This is being brought by a separate sovereign, Georgia. In the United States, you can be charged both federally and at the state level for the same crime, and that's permitted. So you have Georgia bringing the case in a much more complicated way, alleging a RICO conspiracy and bringing in all these co-defendants to be tried together.
And so we have these state charges moving forward. The variety of different defendants, some going to trial, some taking deals, some we're waiting to find out. Then we end up in this situation, the trial of Michael Roman, where various allegations have come forward about the special prosecutor and district attorney Willis, and basically, without needing to get too into the scandal, what is alleged to have done, and more importantly, why does that pose kind of a legal issue as opposed to just a personal one?
Well, the attorney for Michael Roman, Ashley Merchant, looked at a variety of circumstantial evidence that suggested, and direct evidence, that there was a personal relationship, a romantic relationship between Nathan Wade and Fonnie Willis. Some of that circumstantial evidence we've already talked about. He doesn't seem qualified for the job. He divorced his wife the day after he got the job. He's billed $700,000. His billing looks extremely suspect. At times he's billing for 24 hours in a day, or claiming that he spent 8 hours in a day reading case summaries, which would be an unusual use of time for a lawyer. You normally read just the case, and a summary would take less time. So she looked at all those allegations, and she basically is alleging that this indictment and these charges were meant in part to enrich her partner. Now, I will say I wrote an article in the New York Times before this all happened saying, gosh, this seems like it's being brought in an unusually convoluted and difficult way. So, for instance, Fonnie Willis used something called a special grand jury, which means like an information gathering jury that we almost never use in Georgia. She used Nathan Wade on that really heavily for a year. And that's part of how he racked up such enormous bills for the public, about $654,000. So basically, she is alleging that there is a conflict of interest here, that this undisclosed romantic relationship enriches Nathan Wade, who is the romantic partner of the DA, and also that some of that money has come back to her in the form of meals and vacations. He's bought her plane tickets. That has since been verified in filing by Nathan Wade's wife, Joycelyn Wade.
And so we have this money coming through, and given that the special prosecutor is appointed, this may be a simple question, but why is it an issue? What sort of incentive, since in a way they're both on the same side, as it were, Wade and Willis?
Well, in theory, a prosecutor's client is not the state, it's justice. So you always want prosecutors looking solely at whether it's correct to bring a case without other incentives. To that end, Georgia prosecutors actually swear an oath that they will not take any compensation other than the compensation from the job. And that is specifically to ward off the sort of conflicts of interest you might get if you, I don't know, work part-time at a car dealership or doing legal work in an office. Here, she's getting additional money above and beyond her job, but also she's got a romantic partner she hasn't disclosed, and she's thinking about his welfare. Well, now she's considering something other than just justice in the case. Now, to Georgia Rule 1.7, professional ethics, You can't continue on a case if there's a significant risk that your other interests will materially affect your choices. And that's what Ashley Merchant is saying. She's saying, listen, you brought the case in this complicated and difficult way. You've allowed for all this padding of billing, and you've done it because you have this ulterior motive we didn't know about until just now.
Now, you mentioned this evidence being circumstantial. The question then arises, does it have to be actual interference, an actual conflict of interest, or is it just perceived conflict? It's probably because of course in Australia at least we have had both. I know the most famous federal one is Communist Party case, where you had the Chief Justice of the High Court being from the same party as the Prime Minister, and then he judged to back the Prime Minister's legislation to ban communism. So is it actual or perceived that's relevant here?
The standard is whether there's a significant risk, and public perception plays a role as well. So, for instance, Judge McBurney, in an earlier part of this case, recused the Fulton County District Attorney from remaining on this case because she had, against one of the co-defendants, because she had endorsed his political opponent. And that conflict of interest, even though he said, well, we would need a wiretap to prove it actually affected your choices, now there's such a perception of bias and such a possibility that your endorsement is why you're bringing the case. You can't stay on there anymore. So a significant risk is the standard, and you don't have to prove that it actually affected the choices to get a disqualification.
And so then that brings us to what are the effects of this, and what might a court, as we kind of look at the past case law, look at this. I know in the past there have been issues with District Attorney Willis with a case involving the lieutenant governor. What kind of standards apply? What does a court look at to decide if a conflict reaches that threshold where a prosecutor can't continue?
To some extent, it's just a gut check. There's no case right on point. This has never happened before. We have cases that say that special prosecutors cannot get fees for winning a case. They can't have that improper motivation. We have a case that says that a district attorney can't be a witness and also serve and also have his office stay on the case. There's nothing quite like this. So all you can really do is look at the language of the rule and say, to you, Judge McAfee, does it look like this is a conflict of interest? Now, my gut says it is. Judge could disagree, and we could both be right. It's sort of a matter of opinion to some extent, and judges get a lot of discretion on what choice they're going to make.
We are considering this in the context of the trial of Michael Roman, but obviously there are so many other co-defendants. So does the decision in this case automatically apply to all those others? Does it have to be individually considered for each of the cases here?
It does have to be considered individually. So, for instance, in the Burt Jones recusal, where this is the lieutenant governor of Georgia, his case had a recusal and none of the other people's did. That was a judge's ruling. So, on the other hand, in this case, the improper financial motive seems to affect everybody equally. It's got nothing to do with the facts of the case or the strength of the case against each defendant. It's about whether there's an improper motivation not to dismiss the case, not to offer better terms on the case, and not to simplify the case. That is really the conflict that is alleged by Ashley Merchant.
The method of this case, is that just because Georgia prosecutors like big RICO cases? Is because of the political nature of this case that it's being treated differently? Why is it such a mess?
Well, Fani Willis has shown a proclivity to bring these sorts of cases. She was the one who had tried to jail all those teachers for the alleged cheating scandal. She had brought a similar case against a guy named Young Thug, RICO case against a guy for gang activity that had 8 months of jury selection and is just now getting to the facts of the case. So she likes them. But also, stretching the case out means more time in the headlines, more news attention, more opportunities to raise funds for re-election. And now we have this third concern, more money for Mr. Wade.
As we move beyond this case, does this tell us anything about the state of prosecutorial power in America? As you said, the DA can be more powerful than a judge. Does it tell us anything sort of beyond just the immediate excitement of Trump? Does this case tell us anything broader about kind of the American justice system?
Well, we've heard prosecutors say that Fani Willis can do whatever she wants with their budget. There's just an expectation of having no oversight of how those public funds are spent once it's in the kitty. And there's also an expectation of prosecutors of just minimal oversight generally, nobody looking over their shoulder, nothing but their own conscience to make them do the right thing. And when that fails, things go wrong. I don't think any person who expected oversight would have tried to do things in this way. There really were no efforts at concealment, just kind of the hope that nobody would notice and say anything. And I think that prosecutorial expectation is really part and parcel of how our system gives so much grace to people who are given that role and relatively little to people who are charged with crimes.
With regards to the moving past this case, presuming that somehow we get a prosecution brought again, whether that be with the current prosecutor or a different special prosecutor, and that gets brought in, let's say there's a conviction. Of course, we're not going to say whether or not there should be a conviction. We don't want to get into that mess. But saying there is a conviction here, how would that affect Trump's ability to run in the election in November?
Felons can run for office in the United States. In fact, you can serve in office from prison. There is no rule against it. You can't vote if you're a felon. That's the 14th Amendment, but there is no rule against being in office while a felon.
I seem to recall there was, I think it was 1919 or 1920, there was a case about a socialist who was doing anti-war activities during World War I who ran for office from the prison. Yep, ran for office from the prison. So it's very odd for Australians because, of course, if you're in prison for more than 3 years, you can't vote for the next election, of course. So it's a very, very different context for that. But I guess putting it in the broader context of other cases being brought regarding his ability to run in other states, of course, although again, that's probably beyond the scope of this interview here. How would the broad picture affect whether his credibility, although I guess as a populist, his supporters were going to love him, his opponents are going to hate him anyway. How is this in the broader picture of these other insurrection cases affect it more generally?
I mean, his take is that he's being persecuted by unfair Democratic politicians. And certainly it doesn't help that Bonnie Willis has been kind of caught in this ethically compromising situation while bringing the case against him. There's a common theory among Republicans in America that these indictments help him, that they solidify Republican support behind him and make it easier for him to win the primary and become the nominee of the party because people feel he's being unfairly persecuted. Now, that viewpoint strikes me as crazy, but a lot of people really do feel that way.
So it's kind of, it's so basically the lines are already drawn, so it won't really affect anything in the big picture then, because of course people who are going to hate him will hate him, people who will like him will like him. I guess the question is, because I was talking with Elijah about this a few months ago, and Elijah said to me that apparently there's no pardons under Georgia law for this offence. Of course, it is an offence brought under Georgia law, and apparently Georgia law doesn't allow any pardons. Is that correct?
Right. So we don't have any pardons while you're serving your sentence, only 5 years afterwards and through a board. That's because Georgia had a long and corrupt use of pardons through governors that we were trying to nip in the bud. So we took that power away from governors and gave it to a board and limited their power. And also staffed it with people who don't like paroling people or offering them pardons. So in that way, we've reduced the use of it in Georgia. Now, that being said, he might argue if he's president of the United States that he can't be convicted of a state level crime and that it can't count against him. And I couldn't tell you how that will shake out. It's just never happened before. I mean, Aaron Burr was vice president of the United States under Thomas Jefferson, and he was indicted for treason, but he wasn't convicted. We've just never seen anything like it since literally 1807. So we'll see how it goes.
I think just now as we wrap up, we've seen all the ways this goes wrong. I'd be curious, going back to as you mentioned, you've discussed in your previous writing, playing to use the American phrase, Monday morning quarterback. How would you have brought this case, and how would you have handled it in such a way that we didn't end up in a mess that required a half-hour podcast to get a handle on?
Donald Trump, in a phone call with Brad Raffensperger, said that 5,000 dead people had voted. That's a false statement. Giving a false statement to an official in Georgia on a matter that's material to what they do, that's a felony. And you could bring just that claim. You could bring other stuff too, the false electors and stuff like that, as false statements. He would have to establish that he thought it was true. That would be difficult because there's no reason for him to think it's true. It's just a thing he made up on the spot. And the great thing about that argument is it takes out all this other election stuff. It doesn't matter whether the election was stolen. Was this one specific fact true? You could try that in 2 weeks. You don't have to bring 15 co-defendants in, and it's still a felony, which is what you're trying to get. You could have tried that in 2022. You could have tried it in May of 2021 and done it. And the fact that instead we've chosen this whole other way of doing it suggests to me that the goal was not to get a conviction so much as to get all the benefits that came with bringing the prosecution.
So I guess there's a final question here. Now, of course, the DA being elected, let's say that the DA is obviously unelected the next election, which will probably happen based on this, based on these allegations. Let's say a Republican gets in instead. Does that mean that it's going to be dropped like completely? Is this a partisan issue, or is it more of a legal issue?
It's a partisan issue. A Republican would likely drop the case, but Fulton County is so Democratic, I don't think a Republican could ever win there. So, on the other hand, a competent prosecutor could still come in. We're still within the statute of limitations, the time to amend charges. You could still bring the simple version of this case and try it before the election if you wanted to. It doesn't seem like anybody does.
Now, I think one final thing I want to bring up is you're talking about district attorneys. Can other attorneys from other districts bring the case? Or is it only from this one district?
The crimes occurred in Atlanta, which puts it within the venue of Fulton County, which is the Atlanta County. So it would be more difficult to tie things that Donald Trump did to other parts of the state because Brad Raffensperger was in Atlanta, the false electors were in Atlanta. All those things give it that particular place to try the case.
Well, I guess with that note of being partisan, it's probably a good spot to wrap up there. I guess it's going to depend on who wins the next election, because if this case gets dragged out, we could see Trump as president and facing this indictment in Georgia, which is going to be a very interesting position to be in, especially considering he can't be pardoned. But I think on that note, thank you very much for joining us for this, Andrew. We're very glad you can make the time, considering time zones are an issue for us every time. So thank you very much.
My pleasure. Nice talking to you, gentlemen.